Yeah, it's still going on. All right, I'm gonna go ahead and call the meeting to order. Thank y'all for being here. I know we got a lot going on today. In fact, I know several of us are on the Public Health Committee, and they've got some stuff still going on down there. So hopefully this won't take too long. We can get this done, get out of here. Maybe we'll get back down there for that. But we do have one bill that I want to bring up today. It's Senate Bill number 2097, Mississippi Real Estate Commission required to establish pilot program using administrative hearing officers. At this time, I'm gonna call on Senator Sparks. Senator Sparks, if you will explain what we're doing here.
Thank you, Mr. Chairman. This bill may look familiar to you. We had Senate Bill 2624, which passed out of this committee last year, passed in the House and Senate, and ultimately was vetoed. We looked at the veto message. We've talked to the governor's office, and a few things that we've adjusted. We believe we've got a bill that will serve the purpose that it was intended for. This bill deals with the licensees of the Mississippi Real Estate Commission. A couple of things that the bill does. This is mainly dealing with disciplinary issues that upon an allegation leading to a preliminary investigation or a full-blown investigation, there's a notice provision. Brokers have licensees that work underneath them, and they're called a responsible broker. We want to notice that responsible broker if someone that's a licensee of theirs has a violation. The second thing that was a big issue last year and continued to be throughout the last several months is that there were not a concise or available set of written guidelines and rules as it related to discipline. There have been some efforts to produce those. There was a set of rules promulgated by the commission that was actually presented to the Secretary of State's office on January 5th. Now, of course, that's several months ago. We'll see what the public comment is on those rules, but that's not going to affect our legislation because a couple of things that were lacking. The first was a standard of proof. You have to have an evidentiary standard of proof, and that was not present. So in this legislation, we've established a standard of proof as preponderance of the evidence. That was a little different from last year's version, which was clear and convincing. We also have a notice provision that if you have a complaint lodged and you desire to have a hearing, that you recognize you have a hearing option before the commission and the commissioners, or you have a hearing option before a hearing officer appointed by the Attorney General's office. It would still be the commission's responsibility, MREC's responsibility to, quote, present, prosecute their case, if you will. That has not changed. One other thing that was stated last year is that out of 130 some odd cases, all but one of them were satisfied by agreed order. Searching through the statutes and the regulations, I found no authority that they could enter agreed orders. So we've actually put agreed order language. We don't want to take away agreed orders. We're not forcing any hearings. We're trying to offer a concise set of rules. We're trying to give a standard of proof so that all of these hearings are fair to everyone that's involved. The final thing is that if you have a complaint against you, you go through the hearing process, whether it's before the commission or before the Attorney General's hearing officer, and you are not happy with the outcome, you can appeal. That appeal right has been available under current and existing reg and law. But there's something called supersedious, which means if I appeal, that I can continue to practice while my appeal is being decided or heard. And it also gives the commission the opportunity to remove that supersedious if they believe it's some outlandish act that is so bad that it's unsafe for the public. But that is a explanation of the bill. And again, it's very similar to the bill we had last year. I would yield any questions.
Any questions for Senator Sparks?
Mr. Chairman, I have a motion.
All right.
Title sufficient do pass.
We have a motion, title sufficient to pass. All in favor, say aye.
Aye.
Any opposed? Have a motion, rise and report. Rise and report, bill passed.